Hello friends, good morning and welcome to EduSat Live Lectures. Friends, today in trademarks we will be talking about procedure to obtain trademarks registration. To discuss this topic we have with us our subject expert Mr. Ashwini Siwal. Mr. Siwal is Assistant Professor in IP and Data Security Laws, Faculty of Laws, Delhi University. Without further ado, I would like to welcome Sir to our studios and request him to start the lecture. Welcome, sir.
Thank you very much. Good morning, viewers. Well, our today's agenda to discuss procedure to obtain the trademark registration. Well, friends, so far we have discussed and learnt about the trademark nuances, especially in particular the grounds for the refusal of registration, wherein we discussed section 9 and 11, enumerating certain grounds for the refusal of trademark registration. Well, friend, when one learns those grounds for the refusal of the trademark registration and the prohibitions covered under section 9 and 11, I believe it becomes very important for the applicant to know some of the intricacies relating to obtainment of the trademark registration, or say some of the procedural intricacies. So our today's discussion would revolve on the procedural intricacies and nuances to obtain the trademark registration. Well, friends, as far as the procedure to obtain the trademark registration is concerned, you see, it sometimes called trademark prosecution. Well, this trademark prosecution comprises so many things in it. It comprises filing of the trademark application, then there comes the examination of the same, then the advertisement of the application takes place in the trademark journal. With the advertisement of the application of the trademark in the trademark journal, you see, oppositions are invited from the aggrieved parties or from any person interested in opposing that particular trademark application. Then the final thing is the registration that takes place after the disposal of the opposition proceedings. Well, friends, we have to see all these intricacies, all these steps just mentioned by me, which are basically the steps for trademark prosecution and which ultimately results into the trademark registration in the register of the trademark board. All these steps we will discuss one by one, but before starting it outrightly, at the very outset, I would like to first of all tell you some important points about the trademark registration. Well, friends, some important points which to my understanding are to be told to all my viewers at this juncture are as follows: that the trademark enjoys protection in respect of goods and services for it is registered. Though even a non-registered trademark is a good trademark and can be sort of used by the person without getting it registered. But when the person gets the registration done, then he enjoys it in respect of those goods or services for which he or she has registered that trademark for that particular class. Even otherwise, if he does not register it, then also he enjoys the protection, but not the protection which is provided to the user of the trademark by purview of Trademarks Act 1999. Rather, he or she enjoys the protection under the common law in the form of the passing of action. He can institute an action against the infringer, against the wrongdoer, against the unauthorized user of his or her trademark. But when he gets it registered for a particular class or for a particular class of goods or services, he enjoys the protection through the Trademarks Act 1999 under section 27 as well as under section 29. You see, he is given a trademark protection where he can institute an infringement against the infringer. Well, if we go ahead with another important point, same trademark on goods may be registered in many classes. Well, friends, as far as this point goes, it says that the same trademark on goods may be registered in many classes. Well, I initially propose a trademark to be registered on one particular class of goods or under one particular class of goods. Later on, I realized that I should continue with that trademark on some other goods as well, falling into some other class. I can get the same trademark registered by filing a fresh application or a separate application. So the same trademark can continue to be a good trademark for different classes of goods, or in many classes it can be registered, but it has to be registered separately by paying the separate fee prescribed by the rules or say trademark act as such. Well, then there comes another important point, friends, that there can be different proprietors for a similar trademark. Well, friends, I have one instance to make you understand this point, that there can be different proprietors for a similar trademark. The trademark is similar, but the different proprietors are using it. It's a situation which looks very unfamiliar a situation, because it is not allowed to use a similar trademark by different proprietors unless they both have either registered it or they both have got the distinctiveness or acquired the distinctiveness over their respective trademarks. I have an example to make you understand. Lux is a trademark for Unilever on the one hand. Similarly, the Lux is a trademark for another proprietor who uses it on undergarments, on vests, etc. Same Lux is used on the one hand by the Unilever, which is a reputed company. On the other hand, same trademark is used by a different proprietor. There are so many examples to be taken and to be referred as far as the use of the different proprietors of the same trademark is concerned, or use of a same trademark done by the different proprietors is concerned. Then there comes another important point, friends, that the law permits the use of same trademark for different classes of goods, and it can be owned by the same or different persons. What does it read? If you read it carefully, it says that the law permits the use of same trademark for different classes of goods, and it can be owned by the same or different persons. Well, friends, this point is highly important to understand, as it says that the law permits the use of the same trademark for different classes of goods. As I told you in the second sentence, or in the second important point, that a same trademark can be owned on different goods or on different classes of goods, as and when the person feels like getting the trademark registered in a different class, or he may in the very beginning, at the very nascent stage when he prepares the application, can mention that he wants the trademark to be registered in different classes or in different, for different goods altogether, and he can own that same or the different persons can own that. What does it mean? If you see it in a practical situation, there can be two persons or two proprietors using the same trademark, the way it happens, the way I just gave you an instance of Lux. Or say, you see, same trademark can be given or can be registered for different goods or for different classes covering different goods or services. There are several classes. If you remember and recall the classification which I discussed in the very beginning of this lecture series, where I told you that there are 34 classes covering different goods. As far as the NICE classification of goods and services is concerned, it covers provides 34 classes covering several goods, and then 11 classes covering several services in that. So whosoever goes to the registry or for getting the registration done, he or she has to mention it specifically in the form that he wants the trademark to be registered under this particular category of a NICE classification for goods, or if he is seeking it for services, he has to mention the class separately. So there are in totality 45 entries or 45 classes. You see, 34 are for goods and rest are for the services, and all kinds of goods or services are tried to be covered by purview of those classifications, which is an international classification, which is termed as NICE classification. Well, friends, another important point to be understood and deliberated at this juncture, that the trademarks are territorial in nature. Whenever the person gets the trademark registration done, then he fetches a right which is territorial in nature. He cannot enforce his right in another territory where he has not got the registration done. I mean, except in a case where his application is a conventional application or an application of Madrid Protocol, where he can even prevail his registration or his marks registration even in other countries of the signatory nations of the Madrid Protocol as well as of the convention application. But if his trademark is not through the convention application, then it remains territorial in nature. even in India, if he has got it registered in one territory, it cannot be used in another territory. But if somebody tries to use it in another territory, say in Pakistan or say in America, then that person can use it without without the permission of the original applicant, without the permission of the owner of proprietor of that trademark. So it is purely territorial in nature. It has got no concept of global trademark or something like that. That does not take place unless it is filed through the Madrid system, which allows and encourages the international filing of the trademark by single e-filing. Well friends, after that, let us jump straight away to the 4 quadrants of trademark registration. These 4 quadrants of the trademark registration are covering every aspect which is to be seen by all the learners to understand the trademark registration process, especially the procedural part of the trademark registration. Well, let us see what are these 4 quadrants. Whenever there comes a question of trademark registration, the 4 things that are there to be understood. The very first is who can file the trademark application. Then there comes the next question, when to file it. What is the appropriate time of filing the trademark application? Is it required at all, or there is no requirement of filing the trademark application? Then how to file the trademark application? Well friends, filing of a trademark application is very subtle an issue, is an issue which has to be dealt very meticulously by the applicant concerned. So this third quadrant or say third stage or step, how to file, is highly crucial and important to all my viewers to understand. Then where to file? I mean, finding out the jurisdiction or finding out the registry is important for filing the trademark application. So I am going to deal with all these approaches one by one in detail, starting from the very first question or very first aspect, who can file the trademark application. Well friends, when it comes to who can file the trademark application, first of all I would like to tell you that there are in totality 5 provisions in the Trademarks Act covering and talking about the procedural requirements for obtaining the trademark registration, starting onwards from section 18 and going till section 23. All these provisions are exhaustive enough to cover all aspects, say all 4 quadrants of trademark registration, including who can file, when to file, how to file and where to file the application. Apart from these provisions, statutory provisions talking about the procedure to obtain the trademark registration of the Trademarks Act 1999, there are certain rules, Trademark Rules 2002, which are also complementary or say which are also supplementary to this these 5-6 provisions discussing the procedural requirements for obtaining the trademark registration. Rather, these rules are more exhaustive because the rules are talking about the fee to be paid, talking about the exact jurisdiction where the application is to be filed. The rules are more exhaustive in a sense that they talk every subtle or they provide every subtle information relating to the registration of the trademark. Well, when it comes to who can file, the very first provision, that is section 18(1), tells that the proprietor can file. The proprietor can file the trademark application to the trademark board. Well friends, who is the proprietor here? That's the question of our quest. Who can be the proprietor? I mean, because the trademark law covers even the prospective proprietors or say those who are proposing to use the trademark and those who are already in the use of the trademark. Both are becoming the proprietors of the trademark. One who is using it, prior use constitutes or makes him the proprietor of that trademark, and one who for the first time proposes the trademark to be registered to the trademark board, he also becomes or can be termed as the proprietor of that trademark. So what is to be seen by that proprietor at the time of filing of the trademark application, whether his trademark is distinctive enough or not, whether his trademark can be represented graphically or not, whether his trademark evades all the prohibitions mentioned under section 9 and 11 of the Trademarks Act, or it has to be seen by him that the trademark for which he is seeking the trademark registration does not contravene any of the provisions of the Trademarks Act 1999. So the proprietor has to make sure all first preliminary examination has to be conducted by him before straight away approaching or before going to the trademark board for the registration of the trademark. Well, he can be the prior user, as I told you, or a person proposing to use the trademark. I have certain instances where the prior users are becoming the proprietors by getting their prior trademarks registered. Say for example, we know very popular trademark Bikaner, for the sweet shops and for restaurants chain in India. Well, Bikaner as such is a mark or is a geographical name which shall not be registered as a trademark under the Trademarks Act, because it gets hit or it gets negated by the prohibition provided under section 9(1)(b), which says if the trademark is descriptive then it shall not be registered. But the Bikaner, which is already in use, or say it is in a prior use of the applicant, and he has acquired the distinctiveness over the period of time gradually with the name Bikaner over his business or with his goods or with his services. In that case, you see, by naming himself or by claiming himself as the prior user, he can get it registered by filing the application for the registration. And even if he does not get it registered, even in that case, you see, he gets the protection in the form of a passing of action to be instituted by him against the infringer, against the wrongdoer. If he gets it registered, the certificate of registration gets issued in his favor, and with the help of that certificate of registration, you see, that becomes the evidence to be adduced in the court of law to show that his trademark is a registered trademark and is the registered prior to the registration of the wrongdoer or the infringer. So that is how the registration helps. So I encourage all the prospective applicants for the trademark, if they are using some different trademarks, if they think that their trademarks are qualified or capacitate enough to be given the trademark registration on these grounds, they should preferably register their trademarks, because it becomes a very good piece of evidence to be adduced to the court of law to just establish the prior use. So the person who is using it in already, or one who is a prior user, becomes the applicant or becomes the proprietor of it, and he can file the registration application, or he can enter into the trademark prosecution. And the person who is proposing to use the trademark is also the proprietor, one who just proposes it. I mean, for the first time he has coined a word, he has come up with an arbitrary or a fanciful word, and he feels like getting it registered on his business. By his ingenuity, his application of mind, he has come up with a word which he thinks is distinctive enough, which can be represented graphically and which falls under the subject matter of the trademark. I mean, one thinks that his mark or his word or a letter which he has created falls under the definition of the word mark, then he should get it registered, propose to get it registered to the trademark board. Then there comes another important point, that he must be desirous of registering the mark. Whenever we talk about this aspect, that who can file the trademark application, one who is desirous of registering the mark, he can file it. This is what is written under section 18. In the language of section 18, it is explicitly written that one who is desirous of registering the mark, he should get it registered, and he is the person who is the qualified person to approach the trademark board for getting the trademark registration done. Well friends, this attracts my attention, this particular line, that one who is desirous of getting it registered, attracts my attention, because it poses a question. What if there are several partners in a business, and one partner thinks like or feels like getting the trademark registered, and others are not willing to get their trademark registered? What would happen in that kind of a scenario? Can he alone go to the trademark registry or trademark board for fetching the trademark registration, or does he require to first of all obtain the consent of all the partners concerned? So that kind of a question is quite complicated to answer, unless you know the law relating to partnership, law relating to companies or association or body of individuals. But the proprietor word in itself, as defined in the General Clauses Act, as defined here under the Trademarks Act 1999, covers all. I mean, It includes an individual, it includes association of persons, it includes company, it includes any entity, it includes Hindu undivided family, etc. So there are so many people who are coming under the gamut and ambit of the word proprietor. So whosoever, if feels like getting the trademark registration, say in a Hindu undivided family, if they own some business, if they have some business running on the name of Hindu undivided family, and if they feel like getting the trademark registration done, they can approach the trademark board, and there is no need to obtain, or it may be a situation where the one partner of the Hindu undivided family may require the registration formalities to be done along with all the partners. So that kind of a question should be kept into the mind by all my viewers, and the answer to this kind of a question lies only by knowing the details of the laws relating to partnership, laws relating to companies, laws relating to businesses, etc. Well, as I said, that proprietor word includes any individual, company, association of persons, body of persons, Hindu undivided family, etc. If we go ahead with the next question, when to file the trademark application, we have now understood who can file, I mean who all are eligible to file the trademark application or trademark registration. One important point I missed and I forgot to mention and utter, that if say one is owning a family business or running a family business which is in existence, say from the time of his or her ancestors were also running the same business and one is continuing. Now he wants to get the trademark registration done of their business which is basically into the existence from their ancestors. Well, in that case, friends, even that legal representative can become a proprietor and get the trademark registration done, because the word proprietor includes even the LRs, or say legal representatives of the trademark. One more important point that comes to my mind at this juncture, that it's about the perpetuity of the trademark. The trademark right is a right which goes in perpetuity. It is an unlimited right. It is not for 1 year or say for 10 years, unlike right in the Designs Act, which is given to a person only for 10 years, unlike the right in the copyright law, which is given to the person for 60 plus years, unlike the right in the case of the patent law, which is given to the person for 20 years. The right or the term or the duration of the right under the Trademarks Act is in perpetuity, is an unlimited right subject to the renewal of that particular trademark to be done, to be basically followed by the person concerned, by the applicant I mean. Well friends, now jump to who can file the trademark application. First of all, one who is desirous can file. So when should he go to the trademark board to file the application? At what time? I mean, the suitable time for filing the trademark application. The point is that the trademark registration is the one which is not mandatory, which is not necessary. The person can enjoy the protection, enjoy the exclusivity over his trademark even without getting the trademark registration done or without getting it registered. It means, you see, the law keeps it optional. The law does not make it mandatory. So whenever the one who is desirous of getting it registered feels that the trademark can be represented graphically, and he feels that his trademark is distinctive, and he feels that he should get the legal recourse to get it registered, or he should get it legally registered so that he can get an edge over other competitors and he can restrict and exclude other competitors using deceptively and confusingly similar trademark in the form of an evidence of his registration, then he should preferably get it registered. Another point, you see, whenever we talk about when to file the trademark registration, when the mark is distinctive enough. So what does the distinctiveness mean? Well friends, I discussed it earlier also in a very elaborate manner, that the distinctiveness here means the capacity of the trademark to distinguish the goods of one person or the services of one person from the goods or services of another person. So if you are desirous of getting your trademark registration, and if you know by your primary and preliminary examination that your trademark can be graphically represented, you think that your trademark is distinctive enough, I mean which can distinguish your goods from the goods of other persons, your services from the services of other persons, then ideally it's better and it's advisable to get it registered. This is what all the trademark attorneys and IP attorneys are counseling to all their clients, that their trademark is an asset, is having some, does have a value. So for valuation, for vindicating it, for making it more robust in the market for other competitors to write off their trademark, they should register it. The moment it comes on the register of the trademark board, it becomes a crucial piece of evidence. I can say that it becomes a conclusive piece of evidence. It does not require further corroboration. It becomes a conclusive piece of evidence to be led before the court of law for the registration of that trademark. And it becomes highly important when two people are litigating about the prior use, about the prior date or priority. If they are litigating about the priority, then it becomes highly important to get it registered. When one thinks that his trademark evades all kind of prohibitions covered under section 9 and 11, he should file that trademark. If he thinks that there are certain prohibitions, there are certain grounds under which his trademark can get negated, then first of all he should try to modify and rectify his trademark. Only then he should approach the trademark board for the registration done. Otherwise he will meet the answer in negative and his trademark will get refused under the grounds of the refusal covered under section 9 and 11 of the Trademarks Act 1999. So better to examine it preliminary and then get it registered. So when the primary scrutiny is done by the user and it favors the user to file it, then he should file it. Well, the rest part I will cover later. Thank you so very much, friends. Welcome friends. We have to cover now the third stage or the third step for getting the trademark registration done. That is how to file the trademark application. This aspect, this quadrant is highly important, as I mentioned in the very beginning, that one has to learn all the intricacies, all the nuances of filing the trademark application and learning the procedural aspects. You see, what form is to be attached, what fee has to be paid, where the application has to be filed, how the application has to be filled and processed. So these intricacies are important because if there occurs some mistake, or if the one who is getting the trademark registration application processed, if he misses a point, if he commits an error in filing the proper application, then that application will not get processed. It will face certain hassles and obstructions. So better to file the clean application, better to file the application having no spot at last, or says no such error in that particular application. Well, let us see what are the things that are to be considered at the time of filing the application, or at the time of considering how to file the application of the trademark registration. The very first thing that I would like to tell you, that it has to be filed in accordance with the Trademarks Act 1999, the provisions talking or specifically explicitly covering that aspect, and the corresponding trademark rules of year 2000. There are many rules covered under Trademark Rules 2000, out of which few are in relation, or few pertains to this particular aspect, how to file the trademark application. Let's see which section talks about the application of a registration. It is section 18 only, friends, that talks about the application of registration. There are 5 clauses or 5 subsections under section 18. The very first section of section 18 talks about that the person who becomes eligible, I mean the proprietor is made eligible by purview of subsection 1 of section 18 to file the trademark application. But section 18 itself talks about registration procedure or application of registration also, wherein one has to know or read the language of section 18 threadbarely. If you don't read the language of section 18 threadbarely, then you don't get the idea how to frame or articulate the application of registration. Then another aspect that has to be seen, what documents are to be attached and filed with your application for registration under section 18. So those documents and the details relating to those documents are not given under section 18 itself. Rather, the section 18 uses the word as prescribed by the law, as prescribed under the rules of the trademarks. So the documents to be attached, the documents to be filed with the application for registration, they are to be kind of the idea about those documents we get from the Trademark Rules 2002. So we'll learn what are the forms, what are the different forms to be attached, different documents to be filed, what fee has to be paid to the trademark board for getting the trademark registered. Then now the trademark board in India, or say the Office of the Controller of Patent Designs and Trademarks, situated in different parts of the country, has come up with the open online filing, or say this e-filing has made it very convenient to file the application, because it requires to attach so many documents, and the details of those documents are given in the e-filing portal. I may take you, if I will get the time, to that particular portal where the e-filing can be done, which is rather more convenient option than to go to the trademark office in person and go to the trademark window in person, wherein you will it will consume so many days, or say so much of money is involved in that particular thing. So e-filing has been made open by the IP India, or say Intellectual Property India office. Let us jump to the threadbare reading of section 18, friends. If we talk about section 18, then in the very first subsection it reads that any person claiming to be the proprietor of the trademark, used or proposed to be used by him, who is desirous of registering it, shall apply it in writing to the registrar in the prescribed manner for the registration of his trademark. If you see this slide, friends, under subsection 1, the proprietor of the trademark, who is already in use of that trademark or who is proposing to use that trademark, he shall apply it in writing to the registrar in prescribed manner, and the manner has been prescribed under the Trademark Rules 2002. The manner is not prescribed under the Trademarks Act 1999. Then further it reads that a single application may be made for registration of a trademark for different classes of goods. Well, it just makes it clear that a single application is suffice for registration of a trademark for different classes of a good. We have understood it in the important points dealt by me in the very beginning, that a similar trademark can be owned on different classes of goods by a person, but he has to file the application for getting it registered for different classes. Earlier, there used to be a situation where separate application or independent applications are to be moved, or what to be moved for obtaining the trademark on different classes of goods. But now a single application is suffice for getting it registered by paying the fee payable thereof in respect of each such class of goods or services. So separate fee or say independent fee has to be paid, but a single application will work. So that is how the trademark office has made it convenient, or you can call that they have reduced the multiplicity of the applications, When one person owns a trademark on one particular good or a service, and when he wants to start another business with this similar trademark, he can or he will have to register it separately. So that kind of a multiplicity has been curbed and curtailed by this new clause, which says that a single application is suffice for getting the trademark registration done on different goods or on different services or different classes or on different goods. Further, you see, this section 18 reads that every application under subsection 1 shall be filed in the office of the trademark registry within whose territorial limits the principal place of business in India of the applicant, or in the case of joint applicants, the principal place of business in India of the applicant whose name is first mentioned in the application as having a place of business in India is situate. I mean, this clause talks about the territorial jurisdiction or finding the place for the registration. So I'll cover this in the later part where I'll deal with where to file the trademark application. But a reading of section 18 is required by all the seekers of trademark registration or all the learners who are feeling like becoming an applicant of the trademark registration. It covers one proviso also that I'll cover later, not now. Then further, this section 18 under subsection 4 reads that the subject to the provisions of this act, registrar may refuse the application or may accept it absolutely or subject to such amendments, modifications, conditions or limitations, if any, as he may think fit. Well friends, as far as subsection 4 is concerned, it says that the registrar has to either refuse the application or he may accept it absolutely or subject to such conditions or amendments or modifications as he thinks fit. So whenever the person files the application, he has to make the preliminary scrutiny of his application. But if the trademark registrar finds that the application is liable to be rejected, is liable to be accepted, it is his discretion, but that discretion is guided one. He cannot discriminate against the person because of his discretion that lies with him. But undoubtedly, he has got the discretion to deny the registration or refuse the registration on some of the grounds of the Trademarks Act 1999. And he has got the power or a discretion to amend the application or ask for the amendment in the application, ask for the modification in the application, ask for some conditions to be first fulfilled by the applicant. Only then he will accept it absolutely, otherwise he just accept it partially. This is the procedure one needs to learn. Then there comes the last clause of section 18, which reads, in the case of a refusal or conditional acceptance of an application, the registrar shall record it in writing, the grounds for such refusal or conditional acceptance and the materials used by him in arriving at this decision. Well friends, this aspect tells us that the discretion given to the registrar is not a unguided, unfettered discretion. This discretion is guided and he has to provide a reason for the acceptance as well as for the denial of the application, or as well as for the partial acceptance of the application. So it has to be a reasoned ousting, it has to be a reasoned acceptance. If he does not procure the reason, then it means he is going arbitrarily against you. You can challenge his arbitrary order to the Intellectual Property Appellate Board, which is an appellate authority for matters pertaining to intellectual property. Well, let us see what are the documents to be attached or say fixed along with the application made by the person who is a proprietor desirous of making the registration done or getting the registration of the trademark which he is using or which he is proposing to use. By getting his application accepted or for getting his application accepted, he has to furnish some documents, he has to attach certain documents with his application. What are those? Let's see one by one. Well friends, for ordinary trademark application, form trademark 1 has to be supplied or furnished by the applicant. Well, I have highlighted or colored this important point for ordinary trademark application. What does the ordinary trademark application mean? Ordinary trademark application here means an application for obtaining a trademark on goods or on services falling in one class. Single application for a trademark to be registered own goods or services falling under one class, that is called an ordinary trademark application. For that, form trademark 1 has to be attached, and that is available. This form trademark 1 is attached is available online. One can access and download it from the trademarks registry office or from the website of the Indian Intellectual Property Office, from IPO, I mean Intellectual Property Office of India. Further, it says that documents in the case of multi-class trademark applications, then form trademark 51 has to be attached. What does multi-class trademark application mean here? I mean, where one seeks to get the trademark registration done in different classes on different goods or services covered under or falling under different classes. That is called multi-class trademark application. And we have understood it that similar trademark can be owned by different proprietors and can be owned by one single person on different goods or on different services. By getting it registered, by filing a multi-class trademark application, and what is the attachment to be attached? That is form 51, which has to be attached with this application. Then there comes the third one. For convention trademark application, form 2 and form 52 are to be attached in the form of the documents for this making this application exhaustive and appropriate. What does convention trademark application mean? I mean the application where national of other nation is coming to our country for getting the trademark registration. He is not required to come in person for getting that done, but he just files the convention trademark application where he mentions the name of India as one of the respective nation where he seeks or desires of getting the trademark registration done. This is what the Madrid Protocol facilitates. This is what the convention application facilitates. So whenever the person files the convention trademark application, he has to file it along with the documents which are form 2 and 52 provided on or are available on the Indian Intellectual Property Office or its website to be accessed and downloaded by the prospective applicants for this particular trademark application. Further, it covers certain trademark rules of EWAT 2002, which says whenever we talk about documents to be attached or fee to be paid, we have seen what are the documents to be attached, or say some of the examples of the documents to be attached we have understood or seen. Then there comes the next important question: what is the fee to be paid? What amount has to be paid to the trademark board or the trademark registry for getting it done? That is provided under Rule 11 and 12, and that Rule 11 and 12 of Trademarks Rule 2002, it regulates or governs the filing etc., filing of fee, filing of documents etc. It covers all the aspects. Let us see that this rule number 11 and 2 says that trademark forms and first schedule are provided on the Intellectual Property Office, and the details are given on that particular link on your screen. If you go to the IP India office and if you follow this link given on your screen, you will get to know what are the forms to be attached, what is the fee to be paid, how much fee to be paid, where it has to be paid, in what manner it has to be paid. Now, as I said that even e-filing is open, then the fee can be paid online by internet banking or by net banking or in many other manner one feels comfortable. So you see, this question that how to file the trademark application, I hope that you have got it very exhaustively, that there are certain forms, there are certain rules to be followed for knowing the fee, for knowing the other details to be followed and complied with by the person seeking to register the trademark, registered under the Trademarks Board. Well friends, after that we have now reached to the next stage, which talks about where to file the trademark application. As far as this point is concerned, that where to file the trademark application, we have section 18 subsection 3 covering it clearly that the jurisdiction or the appropriate jurisdiction has to be found out by the seeker, by the applicant. So the appropriate jurisdiction or the appropriate place where the application for the trademark registration will get processed or will lie is the place where his principal place of business is situated, where he runs his business, where there are more than one applicant. Then the first applicant's name is mentioned and his address is mentioned. At that address the application will follow, provided that if you see the screen, the proviso reads of section 18(3) that where the applicant or any of the joint applicants does not carry on business in India. It is a situation where they are not carrying the business in India, they have business outside India, but they are feeling like or are desirous of getting their trademark registration in India. Then the application shall be filed in the office of the trademark registry, within whose territorial limits the place mentioned in the address for services in India is disclosed in the application. So any place which they have made their place of service, where their office is situated in India, at that place you see the application will lie, or in that particular jurisdiction his application will lie. Further, you see on the trademark registry website itself, or say on the intellectual property office website itself, territorial jurisdiction of trademark registry offices are given. These are the territorial offices covered on your screen. One office of the trademark registry is in Mumbai. It covers state of Maharashtra, Madhya Pradesh, Chhattisgarh and Goa. Another trademark registry lies in Ahmedabad. It covers under the Ahmedabad registry there comes the territory of Gujarat, Rajasthan and Union territories of Daman, Diu and Dadra and Nagar Haveli. Then the third office of the trademark in India is Kolkata office, where state of Arunachal Pradesh, Assam, Bihar, Odisha or applicants of West Bengal, Manipur, Mizoram, Meghalaya, Sikkim, Tripura, Jharkhand and Union territories of Nagaland, Andaman and Nicobar Islands are covered. New Delhi office covers applicants of J&K, Punjab, Haryana, Uttar Pradesh, Himachal Pradesh, Uttarakhand, Delhi and Union territories of Chandigarh. And the Chennai office of trademark registry covers some of the states which are Andhra Pradesh, Telangana, Kerala, Tamil Nadu, Karnataka and Union territories of Pondicherry and Lakshadweep Island. So in totality friends, there are 5 trademark registry or offices in India where one can file the trademark application, but one has to identify whether his or her state where his principal place of business is situated, where he runs his business, where if he is a foreign national, where his service office is located. He has to find out under what registry office his state falls or territory of his state lies or jurisdiction of his state lies. Well friends, after that you see we have now understood all 4 quadrants of trademark filing, wherein we have covered who can file, wherein we have seen when to file, and then the third important aspect, how to file the trademark application, and the last one is where to file the trademark application, the appropriate place and the jurisdiction. Now you see we have reached to important aspect which I believe it does give the holistic approach or overview of the procedure for obtaining the trademark registration. That is called trademark filing and trademark prosecution. And I told you that this prosecution or trademark filing prosecution, it is covered under section 18 to 23 or enumerated under section 18 to 23 of the Trademark Act 1999. So there are 2-3 important aspects to be seen as far as TM prosecution is concerned. What are those? The very first is TM filing, which we have already learned. I mean, who can file, when to file, how to file and where to file. That is trademark filing. Then there comes the next thing, the examination of the trademark application to be done by the trademark board, by the trademark examiners assigned by the trademark board. That examination is a feature of Trademark Act 1999 covered under section 19 of the Trademarks Act, which says which provides the manner in which the examination of the trademark or application has to be done. Then there comes next advertisement. there happens an advertisement after the examination of the trademark application in the trademark journal that comes weekly, or on every Monday the IP office on its website displays or advertises the trademark journal, where the new applications they have received in last week does get advertised, and on those advertisements they receive or they invite oppositions, and after the oppositions dealt by them, the registration take place. So the entire prosecution of the trademark registration is in front of you now on your screen, and it includes 5 important aspects. One is trademark filing, examination, advertisement, opposition, registration. Let us take up all these aspects one by one. Well, as far as the examination is concerned, friends, examination on the grounds of refusal of registration has to be done under section 9 and 11. We know that there are certain prohibitions covered under section 9 and 11, and those prohibitions covered under section 9 and 11 are absolute prohibitions and relative prohibitions for the refusal of registration respectively. They are to be looked at. The application of the applicant has to be scrutinized and gauged on those prohibitions, on those particular obstructions placed, and then there come that the registrar does it. I mean, he scrutinizes, he examines the application. The registrar sometimes do accept of the application absolutely if he finds after the examination that this application is spotless, is immaculate application and can be accepted absolutely, he accepts it. But if he finds that there are certain improvements or modifications required, then he refuse or may put certain conditions as per section 19, as I told. Then you see what happens after the examination, or say he puts certain objections, and those objections are to be met by the applicant. What is section 19 says in that regard? It says that if the objection is raised on official examination report is issued by the registrar within 3 months to 1 year of filing. Well, friends, if any objection comes, an official examination report is issued on that examination within minimum 3 years or maximum 1 year of filing of that particular registration of the examination. After that, what happens? I mean, either the applicant modifies or say rectifies his application if there are certain conditions put by him, or rectification sought by the registrar, or he does not rectify or modify. If he does not rectify, in the later case where he does not rectify, his application is deemed as abandoned, as if he never filed the application, as if he never applied for trademark obtainment, and others may get leeway or a benefit if there happens a abandonment of the application, because others will become entitled to file the application for the registration of the similar trademark which he wanted to register, but as he did not follow the process properly, then his claim got negated. Well, friends, after that, after the examination, the advertisement takes place. And what happens in the advertisement? As I told you, that after examination and its acceptance, after the examination of the trademark application done by the registrar on the grounds of section 9 and 11, on other provisions of the Trademarks Act, and after accepting it, he does what? He advertised the application under section 20, and that advertisement goes in the trademark journal, which comes weekly. You see, that journal, trademark journal, comes weekly, and it is available online, it remains available online on the trademarks registry website, and it gets displayed and demonstrated every Monday, and it covers all the trademarks filed in last week. So it is a weekly publication and appears every Monday, available on registry's website. What happens with this advertisement? What is the purpose of the advertisement? Well, friends, it is quite logical that with the advertisement of the trademark application, the trademark registrar wants to invite the oppositions, wants to invite those who feel that somebody is trying to get the registration done of a impugned trademark, of a contentious trademark, of a obnoxious trademark which shall not be registered, which shall not be given a trademark registration. So any person can file the opposition invited through the advertisement by the trademark office in the trademark journal on a weekly basis. Then there comes the next stage, that is the stage of opposition. What happens in the opposition? As I told, that under section 21 of the Trademark Act, any person can file the opposition. So it does not read, or it does not say that only the aggrieved person can file the application, only the wronged can file the application. Any person can file, whosoever wants to file it. I mean, even if he has no interest at all, even his locus is there, his standi is there to file the opposition on the trademark if he thinks that trademark is going to be registered in an erroneous manner or on an erroneous footing. Well friends, when does one become entitled to file the opposition? Only after publication of the trademark, not before the publication of the trademark. So one files the trademark opposition only after the trademark application gets published in the trademark journal, not before that. And one has to file it within 4 months from the date of publication. One cannot wait, the trademark office will not wait for more than 4 months. Whatever oppositions or any number of oppositions they get during those 4 months, they are to be dealt by the trademark registrar, they are to be decided by the trademark registrar, or they are to be heard by the trademark registrar. Any opposition coming after 4 months of time period or 4 months after the publication of the trademark application, that shall not be entertained, that shall not be tenable. Well friends, as far as these opposition aspects are concerned on your screen, you see the trademark registrar has to keep in mind that he has to hear both the parties at this stage. If he leaves one party unheard, then it becomes a legitimate ground of that party to approach the appellate authority, that is Intellectual Property Appellate Board. If they are discriminated, if their point or if their logic, if their arguments are not heard, and it is a rule of the natural justice to hear the other party as well. So during the opposition proceedings, the trademark registrar invites the applicant to rectify his mistakes or to answer the oppositions filed in the form of a counterclaim filed or in the form of the counter statement filed by the applicant, as well as the opponent in the trademark board or before the trademark board to be heard, so that they can hear the arguments from both the sides and dispose of the application accordingly. Sometimes it happens that the opposition application is decided in favor of the applicant, then it does not create any havoc or issue. The trademark gets registered because it has been decided in favor of the applicant. But in cases where the trademark application is decided in favor of the opponent, then in that case no registration shall take place of that particular application. Well friends, I believe our today's discussion had been very healthy for all of you to understand this issue. One more important aspect is left that I will cover later. Thank you so very much. Have a very good day.
On that note, I would like to thank Sir for this very interesting discussion, and I would like to thank you, dear friends, for watching our show. Stay tuned and keep watching. Thank you.